Showing on the program today, we talk to two legal practitioners on the issues surrounding the Chief Justice of Nigeria, Justice Walter Onnoghen's arraignment at the Code of Conduct Tribunal over allegations of forced declaration of assets. Funke Adekoya, Senior Advocate of Nigeria, and Olukoya Gumbeje share their thoughts on this. Also this week, securing the independence of INEC in the forthcoming elections was the crux at the 15th Gani Fawemi annual lecture of the Nigeria Bar Association NBA Ikeja branch. Plus, we'll also bring you some of the top trending stories from the courtrooms. That's the lineup on this episode of Law Weekly. Hello and welcome to this episode of Law Weekly. I'm Millicent Walker. Legal practitioners across the country have continued to debate on whether or not the Chief Justice of the Federation can be tried by the Code of Conduct Tribunal, CCT. Well, the view of Senior Advocate Funke Adekoya is that the Code of Conduct Tribunal is competent to try the CJN.
One, I'm not sure it's a planned arraignment. I think the case has now started. I think the CJN has been served. There are issues as to the jurisdiction of the CCT, and then there are issues as to whether the charge itself can stand. What do I think of it? I think it's a good development. I think it's a good development because it enables us, one, to test our legal system, our understanding of the legal system, and the robustness both of prosecutorial skills and also of defenses that are available.
You've talked about procedure, issues of jurisdiction, and even the validity of the charge. But the Nganjuwa judgment that everyone is citing about procedure, you don't agree with that judgment?
Well, the defense have filed a preliminary objection. They're challenging the jurisdiction. And we'll wait and see what the Code of Conduct Tribunal says. My personal view is that the Code of Conduct has jurisdiction because my belief is that this is not, the offenses are not judicial misconduct. I don't agree that Nganjuwa's judgment is relevant. That judgment talks about a precondition. Before a judge can be tried, it has to go to the NJC, giving the impression that, first of all, the NJC must sanction the trial. The NJC must investigate, and if they find a prima facie case of sorts, they will take quasi-judicial action, recommend his dismissal or his termination or his suspension or whatever, and then he can be tried. But I look at Elelu Habib versus Attorney General of the Federation, which was also a matter that involved a judge. And that judgment said that if it is not a matter that involves judicial misconduct, then it doesn't have to go to the NJC. And I think, and the cases stand together. So I don't see why in a matter that does not involve judicial misconduct, it has to go to the NJC first. It's basically, would you say that if a judge was caught drunk and disorderly, or was involved in some offense or some behavior that had nothing to do with his judicial functions, it would have to go to the NJC first before it could be taken before a criminal court? I don't think so.
Despite all of these issues, can the CJN still stay on in office, set up election petition tribunals, and carry on with the whole election process?
That is a matter for his own personal discretion. I would assume there's nothing in the law, but I would assume that he would not, whilst that process is ongoing. I am aware that his predecessor in office, when there were allegations against another set of judges, informed the bar at the time that the bar went to the then CJN to say, these judges are being tried and we don't think that they should be sitting. The former CJN then indicated that in fact they were not sitting, and until those matters had been disposed of, they did not sit. I would assume that perhaps this CJN would take that same view, but that's for him to decide.
What about timing? Do you have concerns about the timing of these whole allegations?
I have concerns about the timing. I see undertones. I personally believe that it was politically motivated. Maybe the petitioners have a view, and see this as the time to take that petition forward. But I think we should also, as lawyers, I think we should look at it outside of the purview of the timing. The timing is unfortunate. But my own personal view is, if you can't do the time, don't do the crime. We see other countries where we see people who go for political office, and they have made up their minds that they want to go into political office, or they want to go into judicial office, or they want to go into legislative office, and they maintain records. We have the recent case of the judge who was confirmed, exactly, Kavanaugh, and how at his hearing, people went back to his attitude and his behavior when he was in secondary school. And so, to me, judges and anybody who holds public office must be like Caesar's wife. They must be above board. They must ensure that they are available to scrutiny at all times. If there's nothing to hide, the timing would be irrelevant, because there's nothing to find, and therefore there's nothing to be afraid of. I do think, though, that the timing has beclouded the issues.
Still on the issue of timing, the president of the bar is on trial, and the chief law officer of the country, who is head of the bench, is also facing charges at the same time. What for you are the implications of all this on the judiciary?
I think it's been a matter of concern within the profession for some time that there are bad eggs in the profession. It's also been a matter of concern that there are bad eggs in the bar, and there are bad eggs on the bench. And we know them. We know those in the bar, and we know those on the bench. The issue has always been who will bail the cat. It seems that either, as far as the president of the bar is concerned, it may be collateral damage, and he's just unfortunately being roped in, whereas the targets are other people. At the same time, my view is that all these issues will eventually lead to a more robust legal profession, because we will then go to the courts, and the courts will then decide, was there a charge made out, whether it is for the president of the bar or the CJN? Was there no charge laid out? And it will give us clarity as to what we are supposed to do and what we are not supposed to do.
So you don't agree with those who say that the bar is on trial when the president of the NBA is on trial, and by implication, the judiciary is on trial when the CJN is on trial?
I think that people who say an attack on the president of the bar is an attack on the profession are taking a very narrow-minded view, and are also bringing non-legal sentiments into it. In the same way that those who say an attack on the Chief Justice is an attack on the judiciary are also taking the same view. We need to clean up the profession. It's as simple as that. If we are to retain confidence in the profession by those who are going to patronize us, if the president of the bar is cleared, it is to the benefit of those who believe an attack on the president is an attack on the profession. It means we are all cleared. At the same time, if the attack on the president of the bar is successful, then those who believe that is an attack on all of us will have to work harder to show our clients that he's just an individual. That's not how we all behave. So either way, we benefit.
Not everyone will agree with the learned senior advocate. For example, Mr. Lukoya Gumbeje, he is another legal practitioner who believes the condition precedent is for the CJN to be reported to the NJC, and that's the National Judicial Council, first. Take a listen.
The Chief Justice of Nigeria remains the highest judicial officer in our country. And I think we should accord him that respect. We should accord his office that dignity. We should accord his office that courtesy. We should accord his office that sanctity. As far as I'm concerned, the charges filed against the CJN before the Code of Conduct Tribunal, as far as I'm concerned, is a misnomer. Is a clear infraction of the provision of the Constitution. There's a judicial precedent in the case of Ngajiwa and FRN that has laid it to rest. So why bring up an issue that has been laid to rest by the Court of Appeal? And it has left nobody in doubt on what should be done in this kind of circumstance.
There are those who say that being the chief law officer of the country, there's a higher morality expected of the CJN, that rather than looking at whether due process was followed or not, it should just answer to the charges and discharge that moral burden that is on him.
It's a constitutional provision we are looking at here. Whether there's a judicial precedent or a condition precedent has been followed. That's what we are saying. Let's look beyond the merits or substance of the issue now. It's a matter of due process of law. Has the due process of law been followed or not? Before you can say, okay, let him come and stand trial. And don't forget that the CJN himself, through his counsel, has said that he has not been served with a copy of the charge sheet. So if he's been served personally, probably you will know what to do in that kind of situation. But the issue is, has the condition precedent been followed? If it has not been followed, then there's a misnomer. Then there's a lacuna. Then there's a constitutional breach. So I think what they should have done was to ensure there is strict compliance with the provision of the Constitution. The provision says a sitting judicial officer must be reported first to the NJC, the National Judicial Council, before he can take any action against him, whether by way of investigation or prosecution. But in this case, none was done. We'll know the end from the beginning, based on the Ngajiwa case that was decided by the Court of Appeal.
But what is the punishment generally for the infraction which the CJN is alleged to have committed?
You could forfeit the monies that were not included in the asset declaration form, which of course were not captured in the one which in the form you filled, or you could be banned for a number of years from holding any public office, or there could be also be forfeiture or some assets and properties and what have you. So these are the punishments that could be imposed by the tribunal on any accused brought before it.
What is the implication for you of all of this on the FG's fight against corruption?
I want to say this very clearly and categorically. I said it before and I'll repeat it again. The anti-corruption war is losing steam. The anti-corruption war is losing steam. And it will get to a point it will boomerang, because there has been repeated and sustained refusal to follow rule of law. Anything we do, we must ensure we comply with due process of law, we follow rule of law. That makes us in a democratic society. Remember that it was the same rule of law that brought the president to power. I'll give you one instance here. In 2015, there was this controversy concerning the president's WAEC certificate. He could not produce it then. His aides and himself, they had to hire the same lawyer that represents the CJN now, Chief Onnoghen, who led the pack of lawyers. And they challenged the jurisdiction of the Federal High Court. What happened at the end of the day? He was able to contest and he won the election. The former governor of Rivers State, Mr. Rotimi, also benefited from the rule of law. You will recall that he became a governor without pasting the poster. He had the primary that was manipulated. He challenged it in court. As at then, the governor that had been sworn was Celestino Mejia. The Supreme Court sacked Celestino and ordered that Rotimi be sworn as the governor of Rivers State. Has he not benefited from the rule of law? So, what are we saying? All of us, we are subject to law, and we should continue to respect the rule of law and to comply with due process of law.
At a time when the president of the bar is on trial and the chief law officer of the country, the CJN, who is the leader of the bench, is also facing charges, what do you think, what are the implications on the judiciary?
A situation where you have the leader of the bar and the leader of the bench on trial, I mean, the outside world will look at us as unserious people. You cannot, for instance, for the president of the Nigerian Bar Association, you cannot isolate Mr. Paul Isoro. You cannot insulate or isolate him from that office being the president of the bar or leader of the bar. So now putting Paul Isoro on trial, it shows that you have put the entire bar on trial. I want to believe crime does not run in Greece State. So what's stop us to wait? Why in a hurry? And I think we should do things in a way that will speak well of our judicial system, that will speak well of our country. It's in everybody's interest that will comply with the rule of law. And I want to assure you that if we do, our country will grow.